Okay. So good afternoon, everyone. Today we'll be discussing about introduction of to IP from the company's perspective as well as from the IP practitioner's perspective. My name is Ramakrishna Damodaran. I'm the trainer for today, and I'm HRD Corp certified trainer. So the purpose of today's session is actually to record the session which will be submitted to HRD Corp for me to be certified as a certified trainer. The session will be at least for 4 hours. We will be doing at least 2 hours plus for recording, followed by other question and answer session. We'll be discussing about topics that may be relevant to the issue that we will be discussing today. As usual, if you have any questions or anything that you'd like to share, please feel free to put in your chat, or please unmute yourself, and you can share your comments or questions for the benefit of the rest of the colleagues who are here today. Now, when you talk about IP, we'll be discussing a very broad subject. From the IP perspective, we will be discussing about what is patent, what is trademark, so on and so forth. And we will be also discussing about recent case studies, recent updates from a few countries around the world, for you to understand how the IP laws and IP practices are being applied by the courts around the world, as well as by the trademark officers or the patent officers, so that when you answer your clients and you guide them as to the strategy, you know very well what is the aim of the client. It's very important to know what the client wants to do, as well as what the law says. You cannot say something that actually is against the law. Obviously, that is wrong. Similarly, we want to say something that actually not beneficial to the client. The ultimate aim is we should be confident enough to tell our clients that your IP application, whether it's patent, trademark, or whatever it may be, it's not registrable, and we should business decisions based on a lot of money. All right. I noticed that the internet is not very stable. I hope you guys can hear me. Can you please confirm that? No?
I'm losing part of the.
Now can.
Yeah.
Just now you are breaking.
Yep.
Okay, so now can you hear me clearly?
Yes.
Okay. All right. So let me share screen now. Just give me a minute. The slides for your info, the slides that I prepared is actually bilingual. The reason why I prepared the slides to be in Bahasa Melayu and English is because we want to give the instruction to IP for those who are not comfortable in English as well. Yeah, because a lot of trainings are being done by practitioners. Mostly they are in English or in Chinese. There's a lot of people who don't speak English and Chinese. They feel that they are a bit disadvantaged in that sense. So, hence the reason why the slides today will be bilingual. Right? So, I'm going to share screen now. Can you guys see my slide? Confirm, please.
Yes. Yes.
Okay. All right. So, as I mentioned, ladies and gentlemen, the topic for today's discussion is actually introduction to IP, right? Now, when we look into IP, right, we need to give a very broad perspective about IP. When I first started doing IP, say year 2000, IP was relatively speaking very unknown. It's still unknown. Not many people understand the concept of IP even today, because it's a very, very complex subject to start with. There's always an overlap between various type of IP, and people use the term interchangeably. All right. For example, a lot of people come. I'm sure you have heard this. A lot of people say that I want to design my pattern. I want to pattern my trademark. I want to trademark my invention. All these terms are being used by those who are not familiar with IP. So the purpose for today's discussion, lecture, or training, or whatever you call it, is actually to give a proper definition of each IP right, so that when you discuss with your clients, remember they are not IP savvy. So you need to actually tone down your presentation, your discussion, so that you can use their own example from their own industry, so that they can understand what types of IP rights that you are discussing. Now, let's go to the first slide. Okay, this is a slide that I always use. I'm sure you have seen this many, many times. Now, I always ask this question to all the people who attend my IP training. Make companies, Microsoft and Apple, to be very, very successful. I'm not taking this only. There are millions, thousands, and millions of them which are very successful. But most of us are familiar with this. So the question that I always ask is, what makes them so successful? Is it because they sell products that people need? Is it because they sell services or they offer services that people need? Is it because they are famous? Is it because there are no competitors? Is it because there are no options? Okay. If you ask me, all of these points that I mentioned may be true to a certain extent. Okay. Of course, they are very famous, no doubt about that. When you say Microsoft, you say Apple, I'm sure all of us at least heard about them, the name, right? Number two, are there no competitors in the market? The answer is yes and no. A lot of our computer systems, they are powered by Microsoft products. That does not mean that we don't have any other systems that can actually power our computers or our laptops. It's just that bulk of our systems or the software, they are Microsoft compliant systems. And we are forced to rely on Microsoft to power our computers, to use our computers. Now, of course, if you look at those who are using mobile phones, especially Apple. Now, the question is, why Apple is so famous? Is it because it's a famous brand? Yes, no doubt about that. But you must also remember, a lot of iPhone users, they complain that their systems are very much locked in a way that, if there's any app you can that is can be used for iPhone, it may or may not be necessarily be useful when you switch to an Android phone, for example. All right. So they are putting a lot of systems in place to control how the market appreciate their products. Now, on the other hand, this actually creates a new issue to the companies, Microsoft and Apple in this case. When we see there are a lot of their products are important, there are millions of customers wanting their products, rely on these products, their services. Now, this will create a so-called competition in the market. People would like to see how they can take away a small portion, or if a big portion is possible, from the likes of Microsoft and Apple. Now, you have your own solutions, you have your own products, you have your own services. Third parties come in and usually they offer something different. Fair enough. Usually they offer something cheaper, also fair enough. But there are cases where people offer the same product with much cheaper rate. Now, this is where things can get very, very complicated. Now, obviously, we call it as a counterfeit product, no doubt about that. But the point here is, because they are cheaper, because they offer certain things that the actual genuine software or the app cannot offer because of the price maybe, there will be a huge demand of customers who need that kind of solutions, that kind of services, that kind of product. Okay. Now, you are creating a situation where you offer your product to the masses, but there's a huge chunk of your solutions being copied by third parties and you don't make any income or any benefit of it. The worst is people use the so-called counterfeit solutions, product services, and then they end up getting negative effect. For example, the software is not compatible with the laptop or the machine that they purchase. Or even some certain cases where it endangers the user. For example, we have seen a lot of companies, a lot of users have reported that the machine could not understand what the user wants, and that did not need. Hence, the machine delivered solution that can be very dangerous to be used, particularly to say kids, infants, and people who are not very IT trained. Right. So that will actually give you a broad perspective how industries, how businesses look at problems. Now, this is where IP comes into the picture. Okay. For those who are not familiar, the term IP means intellectual property. In Malay, it's called harta intellect. Right. Now, when I started doing IP back in the year 2000, when people say, I told my friends, my families that I was doing IP, they were thinking that I was doing property, right? Because obviously the word intellectual is not something that is commonly used. Okay, in this context here, of course, people know what is intellectual, but people don't know the meaning of intellectual property. So they just they understand the concept of property, they understand the meaning of property, they assume that intellectual property means property related, real estate related. Okay, don't get me wrong, people still get that. In fact, last Friday, I met a banker from Hong Leong. She wants to file trademark for her company. So she still thinks that IP means property. So she's still confused about the term IP in a way that she thought IP is actually property related. She was asking how many clients you have, where the property and the sites are located, etc., etc. Right? So now, let's start with the first type of IP, patent. Now, Malaysia introduced patent in 1989. The Act was passed by the Parliament in 1986, and the law was enforced in the country in 1989. If you think about it, the law is about less than 40 years old in Malaysia. Look, put that in perspective. In the UK, the very first patent was granted 300 years ago. Okay? So in developed states, developed countries, patents they are so used to it because we had been there for 300 over years. So people know how patent works, how people apply patents, so on and so forth. But in Malaysia, because if you think about it, less than 40 years since a patent system was introduced in Malaysia, people still don't have a proper understanding what patent is, how the system works, and how you apply for a patent, etc., etc. Now, the first thing I would like to highlight to you is what the law says. Okay, let's break it down here. Now, look at the wordings on your left-hand side screen. Patents, under the law, patents are granted for products or improvement to an existing product or to a process or an improvement to an existing process or a new use of a known product, as long as that product, that process, or that new use is new, is inventive, and is industrially applicable. Correct? This is how the law has been worded. But for the layman, they will find it very difficult to understand what this definition is all about. Now, let me just break down for you. Obviously, the invention which needs to be patented must be in the form of a product or process. Okay, that's very clear, right? Or if you have an existing product or an existing process, any improvement to the existing product or the existing process can also be patented. Or if you have a new product, okay, if you have a product that is known but the use that you are introducing is something new, then it is also patentable, as long as that invention is new worldwide. Okay, remember the law never said the word new worldwide. Yeah? However, the courts around the world has defined that the term novelty, what getting in the head, means new worldwide. Inventive means it has to be of major improvement when the existing current state of the art is considered. And thirdly, your invention must be workable invention. It cannot be merely an idea. Now let's look at the diagram on the right hand side. Okay. Now I like to open this to the floor. Can you put your answer in the chat, or if you want to answer live, please unmute yourself. Now look at this diagram. It's actually a patented invention in the US. What do you think the invention is? Is it a product, or is it an existing product, improvement to an existing product, or is it a process, or improvement to an existing process, or is it a new use of a known product? Can you please put your answer in the chat, please? I'm going to stop sharing for a while so that I can read your answer. So Mr. Suren said it's a new product. Puan Norlela said it's an improvement to an existing product. So we have two conflicting answers. I'm not saying which is correct now, yeah? Let's get the other three to share their answers. New use of an existing product. Okay, so now we have three conflicting answers. Puan Cik Amalina mentioned improvement to an product, which is similar to what Puan Norlela said. And Dr. Chok mentioned it's an improvement to an existing product, which is also similar to what Puan Norlela said and what Cik Amalina said. Now, if you ask me, none of you is wrong. Okay, if you look at the, let me share the screen again. Okay, like let's take Surin's example. He said it's a new product. Okay, okay. So if you think about it, to a certain extent, I agree. It's actually a new product when you look at this, the entire invention as a thing as a whole. Right? Obviously, I'm sure Mr. Surin will agree that you cannot say the truck was new when the patent was filed. Remember, this is a 5 million series patent. Now, in the US, it's already 13 million series. So if you put that in perspective, it's about 40 years, about, let's say, 1980. Okay? In the 1980s, would you consider a truck or a vehicle to be new? The answer is probably no, because vehicles have been there since 1920, 1930. So obviously in 1980s, the truck was not new. Okay. Obviously, if you think about the other part, the basketball stand or the hoop as we call it, do you consider that as a new thing back in 1980s? The answer is probably no, because even if you look at NBA, the NBA has been there for almost 100 years now. Right? So definitely 40 years ago, it was not new. But if you look at this together, there's an item number one. All right. All right. That number one is actually what makes the invention to be new. Okay. So if you ask me, do I agree with Mr. Suren's comment? To a certain extent, yes, because if Suren says he calls this invention as a mobile basketball stand, then I would say it is a new product. At the same time, Puan Norlela, Dr. Chok, and Cik Amalina mentioned that it's actually an improvement to an existing product. I also will agree, because technically you are improving how these two things work. So it's not wrong. Third, I think Ms. Maithili mentioned is a new use of a known product. I can see why she said that, because again, we have a truck all this while being used to carry goods or carry passengers. Now, for the very first time, I would imagine that a truck is being used to carry the basketball stand. So none of you is wrong, okay? But if you think about it, right, the way the pattern has been drafted is that they claim, number one, the item number one, the connecting bar, which connects the truck to the basketball stand. Now, think about it. The invention that is claimed or is being patented here is the item number one, the connecting bar. But when you sell the connecting bar on its own, all right, you cannot call that to be new because connecting bars have been there for many, many years. Even in the vehicle, even the basketball stand, there are many connecting bars there, all right? But what made the connecting bar to be invented in this particular case is that it was made of a particular material, okay, that made it so strong that you can move or you can travel on the vehicle, on the truck, on a very high speed, and the basketball stand will still stand straight and will not fall down. Okay, and it can be used in the industry. Yes, you can bring this, you can drive this with to the car, to the park, to the beach, and also play the basketball there. Right. So if you think about it, what made the invention patentable is not the connecting bar, is not the truck, is not the basketball stand, but actually is the material that we use to produce the connecting bar. Right. So now, when you look at the situation, this situation, right, in most cases, you're going to have objections from the examiner for lacking the novelty or the inventive step or industrial applicability if you're going to focus on the connecting bar or movable basketball stand. But what you need to focus on as a patent practitioner is that what makes the invention be different? What is the problem that the inventor is trying to resolve? Okay. Obviously, the problem that the inventor is trying to resolve is that before this invention was created, all the basketball stands were static in a way that you only have to play where there's the basketball court. Okay. So he felt that there's a need for someone to create something that makes it accessible to the public and anywhere. Whoever wants to play, anywhere they want to play is possible. Now, the thing is, if you make this as a mobile basketball stand, obviously people can literally cut the basketball stand that is static and make it or move it to another place. It becomes a mobile basketball stand. So the selection of the wording, the term that you use is very, very important before you can draft the patent specification. Please do not draft a patent specification without knowing the invention. Remember, what the client is showing to you, what the inventor is showing to you is just an embodiment of the invention. Okay? What you are doing in your patent drafting is that to get the gist of the invention so that you can actually expand the scope to cover multiple embodiments. Now, if you look at this, if you look at the patent claims the material. So in other words, you are claiming a material that can be used to make connecting bars that can be used for multiple applications and not only connecting the vehicle to the basketball stand. That is one of the embodiments. The embodiment is just a use case. There are many, many more use cases, embodiments that you can use to protect the invention. Now, on the other hand, let's say that material is known, connecting bar is known, then unfortunately you may have to limit the scope of the patent of the claims to limit to a connecting bar that connects the vehicle and the basketball stand. So that will be your last option. Covering many embodiments will be your first option. All right. So please do not limit your scope of your patent unnecessarily. This, ladies and gentlemen, you will see a lot of conflict with the inventors. Sometimes inventors, if they understand why we are doing that, they will be very happy. But more often than not, especially the inventors who are filing patents for the very first time, they may not understand why you are doing that. For them, as a researcher, I created, let's say this particular case, the researcher will say that I created a connecting bar that connects the vehicle with the basketball stand. Why are you claiming the material? That's not what I created. That's not my invention. I'm not a material scientist. I'm an automobile engineer. Now you will see the moment you use the term I'm not a material scientist and I'm an automobile engineer or I'm a sports scientist, you will see that he is looking at the invention from a different perspective. He's not looking from the patent perspective, but He's looking from the technical perspective, from his own perspective, point of view. All right. So it is very important for you as a patent practitioner to guide them through the process, why you are doing certain things. Always use the terms that they will understand. Never use, for example, if you are talking to a say microbiologist or you're talking to a biotechnologist, for example, it's very dangerous, not good, in fact, to use something to do with mechanical engineering or electrical engineering. You may be from mechanical electrical, but he is not. So if you are giving examples of mechanical or electrical engineering to a biotechnologist or microbiologist, he will not understand what you're trying to say. So always talk the same language that the inventors speak. Okay? But of course, when the inventor is very senior, he has filed patents many times before. He may not have problems understanding what you're trying to say. So the all can be adjusted accordingly. So that all comes with experience. You need to have multiple interactions with the inventors so that you can understand how you can modify the way you share your comments to different types of what you call inventors. Not everybody sees the same thing the way you see it here. Always remember that. Okay. Can I pause for a while? Is there any question that you'd like to ask so that I can answer your question before I move on to the other section? No? Good. Okay. Let's move on. Okay. Now, when you talk about patents, one of the things that you will see in the patent side is that you must provide a solution to a problem. More precisely, the law in Malaysia, the patent law in Malaysia says you need to provide a technical solution to a problem before you can get your invention patented. On top of your invention being novel, inventive, and industrially applicable. Now, when an inventor creates new things, when they are providing new solutions, they always come up with what we call as a problem statement. That's a term that they normally use, especially in the universities or research centers. They say that this is my problem statement, i.e., these are the problems that they see happening currently in the market. Okay, and that is their objective, i.e., to come up with a solution that can solve at least one of the problems that they have identified. Look at these diagrams here. Some of these are very things that you use every day pretty much. For example, let's look at the top right-hand side, the fan. Okay. A lot of us will have this issue that we have to do cleaning of the fan. We need to dismantle the cover. You need to dismantle the plates. You need to wipe it clean. You need to dry it, and then you have to assemble that. Okay. For most of us, this is not an issue. Okay. For most of us, it could be an exercise that we do on a Sunday. Okay. But one inventor realized that it's actually a problem that I have to do this cleaning once a week or once a month. Okay. Remember, your problem does not need to be a massive or major problem. A minor problem is still a problem. An implied problem is still a problem. Okay. That means something that is not happening now, but may happen in the future is still a problem. Right? So here, Dyson came out with what we call as a bladeless pen. Does that mean that the inventor has solved all the problems? That remember the problem statement? He said that the invention, the current fan needs to be cleaned once a week or once a month. Okay. Does it mean that the Dyson's bladeless fan has resolved the problem completely? Can I have some answers in the chat, or you can unmute yourself, please? Anyone? Has he resolved the problem? Remember, his problem was cleaning. He's lazy. He doesn't want to clean weekly, monthly. Okay? But he created this so-called bladeless fan. Anyone? Doesn't matter, right or wrong. There's no right or wrong answer. You can always. This is for discussion purpose. We solve major part of our problem. Okay, Dr. Chop said it solves major part of your problem. Agree? Is there any other comment? Surin said he solved the problem. Che Amalina said he did not completely solve the problem. Now, remember when you talk about pattern, you don't need to what do you call that? Solve the problem completely, right? But when you have, say that, I hope you can see my screen. If you have 10 problems and your invention only solves, say, one of the 10 problems, in your pattern application, it is imperative, it is important for you to only highlight that one problem. This actually happened in Australia before. Maybe I can give you a bit of background of what happened there. That particular pattern, I don't have the details of the pattern now. It's a very old pattern, by the way. The patent was granted by the Australian Patent Office, but ultimately it was challenged in court. The third party who wanted to challenge the patent attacked the patent left, right, and center by saying that the invention was not new, was not inventive, etc., etc. The court said no, the invention was new, was inventive, and all that, so he couldn't defeat the patent on that ground. So eventually, they attacked the patent because they said that the inventor did not achieve his own objective. In that particular case, the inventor highlighted 8 problems with the current state of the art. And he was only able, from the description, from the patent document, it was shown that he was able to solve only 2 of the problems. The patent was revoked by the court because the court said that when you set your objective, it is important for you to achieve your objective, failing which you failed in your research and development process, and therefore that patent should be rejected. Since then, the way patent drafters started drafting is that they don't highlight all the problems. Even if they have thousands of problems, please don't highlight all. Very important to highlight that only one problem. In this particular case, if I was drafting the patent for Dyson bladeless fan, I will say that it requires the parts to be disassembled, okay, removed, and then subsequently assembled back. Okay, and this is a problem for me, and I want to reduce or eliminate the problem by providing a tool or pen that does not require any form of assembling or removing the parts. See, it's the same thing. Cleaning and non-cleaning, removing the parts, assembling them, and not doing that. Okay, it's the same issue. But the way you highlight, we are focusing on a different perspective. Okay, always draft patent specification as a patent drafter, not as the inventor. On the other hand, if you look at the left-hand side, the guy is eating a big hamburger. Okay, so obviously he's obese. The patented invention in this particular case is actually what do you call that? Belt with measurement. Okay, does it solve the problem that he's being obese, and therefore the moment he starts wearing the belt, he will lose weight? The answer is no, and that's logic, isn't it? You just don't lose weight purely because you are wearing a belt. That's implemented. What makes the invention unique or patentable in this particular case is that the invention tells the user that yesterday your size was, say, for example, 90, and today you're 95. Okay, that means you have put on weight. It's about time for you to. Sorry, 1 second here. Oh, you cannot see the slides. Sorry, my bad. Let me share screen again. Can you see my screen now? Yeah?
Yes.
Okay, good.
Yes.
Okay. So see here, the guy is being obese, I mentioned. The belt is not going to solve the problem, but rather it's actually an indication or like a person or tool that tells you that you have
Sorry, Mr. Ma.
obesity problem. Sorry.
I think your screen.
Yeah.
Now it's back. Yeah.
Okay. Because of the internet issue, if you have problems with hearing me or my slide, please let me know. Yeah. All right. Okay. Thank you. So the next is the butter stick. Obviously, people who actually have used butter, they know that butter needs to be refrigerated all the time. Okay, otherwise it melts. Okay, so the inventor created what we call that a butter stick, which is similar in a way to lipstick, but used for applying butter on bread. Now, if you think about it, right? Can I ask you your own view? Okay, please share your comments in the chat. Okay, will you buy the belt with the measurement tape or the butter stick? Okay, just yes or no. I want to see your answer. Okay, would you buy or will you not buy? Okay, Leila said you will buy both, Leila, or just one of them.
Maybe only one of them, which is the butter stick.
Okay, not the belt. Okay, fair enough. Maitri said the same thing. Chok said no to, I suppose, both. Okay. How about Amalina and Surin? Not the belt. Okay, he will buy the butter stick. Fair enough. How about you, Amalina? You won't buy the belt. Okay, that means you probably buy the butter stick. Now, things that we need to. Can you hear me, guys?
Yeah.
Yes.
Okay. See, this is the point I'm trying to make here is that whether your invention is commercializable or not, or being commercialized or not, is not a requirement for a patent to be granted. Okay, you don't need to sell your product to have your invention patented. Okay, in fact, statistically, only 2 to 3% of patented inventions are being commercialized. Okay, so that means 97-98% of the patented inventions are not being commercialized or they fail in the market completely. Okay, remember, commercialization is not a requirement. Okay, I hope you can see the screen. If you don't, please let me know. Can see them? Yeah,
Yes.
okay.
Yes, you can see.
All right. But also remember, not everything is patentable unless you are in the US. Okay? In the US, there's a saying, everything under the sun is patentable as long as your invention is novel, not obvious, which is similar to our inventiveness requirement, and industry applicable. Okay? In Malaysia, in fact, in most countries that follow the UK system, all right, there are many things which are not patentable. Okay? And I've given a list of items or the so-called inventions that cannot be patented. For example, if you can see here, discoveries, scientific theories, and mathematical methods are not patentable. Let's say if you are the one who came up with P equals to MC squared, technically that formula is not patentable. Okay, so this is where the confusion with software. A lot of people say software being, if you see the number is 0110, all right. So a lot of people assume software falls under the definition of mathematical method, and therefore it is not patentable subject matter information. I beg to differ. I can also tell you that software companies are the top filers in Malaysia for many years. Okay, obviously you cannot claim the software per se because software per se will fall under protection. Okay, but in the case of invention relating to software, the patent owners, the applicants will claim a system for doing something using the software and the hardware. Okay, is to perform something to achieve something. For example, if you are claiming a patent for say a map that helps you to move from point A to point B, you cannot claim the source code of the map. Okay, that will fall under copyright. You can claim a system that actually utilizes your, say, mobile phone camera or your mobile phone itself, or a device that actually powered by that particular source code in order to tell you what is the fastest way to travel from point A to point B, or what is the cheapest way to travel from point A to point B, or what is the way that I can bypass the toll gate or the police roadblocks, for example. All this can be achieved by a system that actually rely on the hardware in the form of a mobile phone or the device, and the software that the inventor has created. Okay, so software is patentable innovation. The next point is plant and animal varieties are not patentable inventions in Malaysia. Essentially, biological processes are also not patentable in Malaysia. Schemes, rules, and methods of doing business, performing purely mental acts, or playing games are not patentable. Method of treatment of human or animal by surgery or therapy is not patentable. Diagnostic methods performed on the human or animal body also not patentable. Now let's look at the item number 4, which is something that every one of us will be affected in one way or another. Methods of treatment of human or animal body by surgery or therapy. So, in other words, if you are performing a treatment of a plant, either by way of surgery or therapy, that method is still patentable. Okay? Remember, only human and animal bodies are eliminated. Diagnostic methods practiced on the human body or animal body is also not patentable in nature. Now, what happens if the diagnostic method is performed outside the human body or animal body? Would you consider that as a patentable subject matter? The answer is yes, because the law is very clear. If the parliament intended only the diagnostic methods practiced on the human body, on the animal body to be eliminated from being a patentable invention, then that is the case. Okay? So
Mr.
diagnostic
Rama,
methods, yes.
Mr. Rama, sorry, your slide is not moving. It's still showing the butter stick page.
Oh, sorry. Something wrong with my internet today, so that's why you will see this problem. Sorry, yeah. Let me share screen again. So guys, if you have problems, just voice out, yeah, because I'm not looking at your screen, so I wouldn't know. Even if you put in the text, I wouldn't know. Okay, so please voice out. Let me share screen again. Sorry about that. Do you see the screen now, where I talk about non-patentable invention?
Yes.
Yes.
Okay. All right. So let's move on. Okay. In Malaysia, there's a thing called utility innovation, whereby inventions which are not inventive, that means which are of minor improvement, can be protected by way of a UI, utility innovation. Okay. So if you look at it here, patents and UIs are pretty much similar concept. Both are under the Patent Act. Okay. There are a few differences. First and foremost, patents can have more than one claim, can be one claim or more. Okay. Whereas a UI can only have one claim maximum. Patents must be patentable inventions must be new, inventive, and industry applicable. For UI, you don't need the invention to be inventive. In other words, minor improvement can be protected by way of our UI. Of course, both are protected for maximum 20 years period from the date of filing. Okay. There's one more additional requirement for UI is that you need to submit evidence of use or evidence why you're not using the invention in Malaysia on the 5th year, on the 10th year, and then on the 15th year in order for the UI to be easier. Okay. Now, if you look at it statistically, 99% of people, patent applicants, don't file UI. The reason being, obviously, UI is not well known because not many countries provide UI or equivalence to UI, number one. Number two, UI being with one claim, theoretically, it is possible or easier to revoke a UI compared to a patent, even though theoretically, again, it's easier to get a UI granted compared to a patent. Right? Put it this way. I have 10 claims in my patent application. I need to show to the inventor, to the examiner, sorry, that all my 10 claims to be patentable in order for the patent examiner to allow my patent with 10 claims. If he has a problem with at least say one of the 10 claims, he will reject that claim, and I need to remove that from my patent application before my patent can be granted. Put that in perspective, I have only one claim for UI. So if I can prove to the examiner that my claim one is novel and definitely applicable, remember, invention is not required, the examiner should allow my UI application to be granted. Okay. So in order to get a UI granted, is theoretically easier. Having said that, it is also easier to revoke a UI, as I said earlier, because you only have one claim. The very same reason, you only have one claim. If you have a patent with 10 claims, as a third party, I need to prove to the court that every one of the 10 claims is not patentable before your patent can be revoked. Let's say I can only prove that 9 claims are not novel, not inventive, or not industry applicable. Then my claim 10, your claim 10 will still be valid, and the court will declare that your patent to be valid insofar of claim 10 is concerned. Put that in perspective, if you have a UI with only one claim, my task in the court is just to prove to the court that your claim 1 is invalid. Okay, so because of that, people who know how patent system works will not pay a lot of money for UI because it's easier to be revoked. Commercially, it gives you a very narrow protection, and investors may not put in a lot of money into a UI compared to patent. That is the reason why a lot of public universities don't pay attention to UI. Although I must admit that recently we have seen a change in the trend whereby some of our clients actually started accepting UI application to be filed. Okay, so some of you will be familiar with those cases here. Okay, now I mentioned your invention must be new. What happens if the invention has been disclosed? In Malaysia, disclosure is defined by way of the word prior art. So for those in the research, they will use the term literature review. In our case, we call it prior art search. Anything that is published, anything that is available is a prior art, which includes verbal disclosure, presentation, publication, online, offline, in any language, anywhere in the world. Remember, your invention must be new worldwide. So a lot of our clients actually have made some prior disclosure. In other words, they have published a thesis or paper. They have gone for an exhibition. They have participated in competition like ITEX. They have gone for like say met with investors and they presented the idea to the investors. So all of this will become prior art. In Malaysia, in most of the countries around the world, in fact, there's a grace period of 1 year if the inventor himself has published or has disclosed the invention. Remember, the grace period does not apply if the invention was disclosed by third parties. Okay? If the invention was disclosed by third parties, technically you are copying that invention. If your invention was disclosed by way of a sabotage without your permission, then you can still apply that 1 year grace period. Okay. Now, this is very, very important because if you miss that 1 year period, that cannot be reinstated. Okay. You don't have any extension to the 1 year grace period here. So, as a rule of thumb, please advise your client never disclose their invention to anyone before the patent is filed. If they are forced to disclose, get them to sign an NDA, a non-disclosure agreement. Or if an NDA is not possible, keep to the disclosure to the bare minimum. If you have 10 features, you may want to disclose just 1 or 2. The advantages, how you save money and all that is fine, but do not disclose anything technical, especially that technical feature is something that makes your intent to be better. Okay, so this is one case study that I always use again in all my presentations. How do you identify prior disclosure? Look at this diagram there. Apple filed a patent for the iPad in year 2004. But if you see these two movies, 2001 is Space Odyssey, 1968. and the Star Trek First Contact 1996. In these two movies, in these two posters, you will notice that the two characters were holding something that looked like an iPad. So the question that you need to ask yourself is that if these two movies kill the novelty of the invention, Apple's invention, and hence Apple's invention to be invalid when they filed a patent in the year 2004? The answer is no. Because in the movies, if you watch the movies, they did not open the machine, the device. They did not show how the invention works from how the features work together to perform the task. Okay, they did not show the source code. They did not discuss anything in any language about how the invention works from the technical perspective. They were just holding a device that so happened look like an iPad. Okay, that kind of disclosure is perfectly fine. That's what I said. You need to keep your disclosure to that bare minimum. Showing the product is fine. Showing how the product works, how the invention works, is not good. Okay, this will give you some statistics. Of course, we rely on MIPO, the Malaysian IP Intellectual Property Corporation of Malaysia, for these numbers. So the figures that I'm presenting to you is subject to what MIPO has published and is subject to possible errors, because it is so very common that we don't have the exact figures, right? So you will see that Malaysian applicants has filed about 1/3 of the patent application filed every year in Malaysia, which is about 7,700 in year 2019 to 8,000 plus last year. So it's always about 1/3, less than 1/3. Okay. But if you look at the number of patents granted, it is not 1/3. It's actually probably 1/9, 1/8 of the application. So the number does not tally. If you really look at it in a simple manner, if you're filing 1/3 of the patent application per year, by right, you should get 1/3 of the patent granted. Okay, it doesn't work that way, unfortunately, ladies and gentlemen, because patent examiners are trained to reject. They will find a lot of reasons to reject your application. Okay, but if you look at the foreign patent owners, when they come in and file the patent application in Malaysia, all right, they most of the time they would have filed the patent elsewhere, like in the US, in UK, Europe, what you call Japan, Korea, China, so on, Singapore, so on and so forth. So when they have a patent granted in other countries, normally Malaysian Patent Office will grant the patent as long as your claim having the same scope with a foreign patent. Okay, Malaysian applicants, very few actually of them file elsewhere. So if you don't file elsewhere, chances of getting the patent granted in Malaysia can be slim now. That's the first point. Second point, remember, it takes years before a patent is granted. Yeah. So the 381 patents that were granted in 2019, I can tell you straight away that these were not filed in 2019. These would have been filed in, say, about 2015, 2017, okay, 16, sorry. Because in Malaysia, it takes about 4 years to get a patent granted. When I see this, a lot of people get surprised. Why 4 years? Why is it so long? By the time my patent is granted, my invention is already audited. I would have come up with a better version. My current version, obviously, let's say I'm in the software industry. Software is something that progresses very fast. Every 6 months, they'll have a new version. So if I had to wait for 4 years, I would have at least 8 versions, which are probably superior than what I filed in 2019, for example, right? That is unfortunately the problem that every applicant faces. In the if you look at internationally, US will take about 3 to 3.5 years to get a patent granted. Malaysia is pretty much on the average 4 years. Okay, but I cannot tell you if you have your invention is something that I will touch on it. If your invention fulfills certain requirements, you can jump queue and the patent can be granted within 20 months, which I will be sharing in a bit. So it's not all bad, so you can still get your patent granted within 20 months, provided that you fulfill certain requirements. Okay. Now, we are in the era of AI. Everyone talks about AI. Everyone talks about ChatGPT. Everyone talks about machine learning, deep learning, all kind of AI tools, right? Now, did you know that AI has started creating invention? Okay, so look at this patent. It was filed by a certain Stephen L. Taylor. Dr. Taylor invented this invention AI, uh, which he named as Dabus, DABUS, which I highlighted in blue there, correct? And subsequently, Dabus invented a few inventions, nothing great. If you see the invention, these are the photos that I put on the top right hand side. These are the things that Dabus created. One is on the material science side, and the other one is a bottle that actually utilizes the material science. Very simple invention, nothing fancy about it. Okay, but what made this case very interesting is because Dr. Taylor named Dabus as the inventor when he filed a patent. This created a new problem for patent practitioners worldwide. For those who are familiar with the patent system, one of the conditions for patent to be filed is that you must name an inventor, and that inventor, for all intents and purposes, must be a human inventor. Okay, remember, Patent Act came in the UK started about 300 years ago. So our laws are pretty much outdated. The laws still do not understand the concept of AI creating things. Okay, the laws around the world actually still rely on human inventors. So this created a new problem for patent practitioners and the examiners and patent officers. When Dr. Taylor filed his patent and named Dabus as the inventor, he got the patent rejected in a lot of countries. You see on the top right hand side, you will see the decision on the petition. The patent application was denied. That's from the US. On the bottom left, you will see the EPO. The EPO is the European Patent Office. They also rejected the patent purely because the inventor was not human. Okay? So the patent was not rejected for other reasons here, only on that ground. Similarly, the patent was filed in Australia. Now, for those who are familiar, for those from the legal background, you will know that in Malaysia, our higher court actually comprises a few levels. Number one is the High Court, followed by the Court of Appeal, and then we have the Federal Court. That's in Malaysia. In Australia, the order is reversed. The lowest of the higher court is actually the Federal Court, and the highest of the higher court actually is the High Court. Okay, so it's a reverse here. So don't confuse. So if you see the top the poster that I have given here, you see here a landmark decision by the Federal Court of Australia that non-human artificial intelligence, in this case Dabus, may be named as an inventor. So for the very first time, few years back, Federal Court of Australia said that human inventors can be machines. Human inventors is not something that you require. Okay, the Federal Court decision. Unfortunately, a few months later, the decision was appealed by the Patent Office, and the High Court of Australia reversed the decision and is now status quo, whereby AI cannot be an inventor. Okay, so in Australia, it's the same, back to square one. However, South Africa, just after the Federal Court decision in Australia, South Africa being a Commonwealth country, they looked at the Australian court decision and they came up with the decision that non-human AI can be an inventor, and South Africa has allowed the patent to be processed and eventually granted. Now, obviously, there was no appeal on South African decision. Okay, so as far as South Africa is concerned, AI can be an inventor. As far as the rest of the world is concerned, that is not possible. So now, question that I'd like to put to all of you is that, can I just stop sharing for a while? Put this situation in Malaysia. Do you think if you file a patent application naming AI as an inventor, do you think the patent will be granted by MISO? Yes or no? Surin said no. Nalila said no. Okay, everyone said no. And maybe Mr. Surin can explain, because you're from the legal background, why you think Malaysia will not accept AI being AI being the inventor, and therefore the patent to be rejected. Maithili, you can also check it.
But I think it comes down to questions of liabilities, of responsibilities, and our legal framework is right now does not actually fit into this concept. How are we going to put liabilities to a non-human entity or whichever?
Fair enough. Now, since South Africa has accepted patent to be granted for non-human inventors, okay, and Malaysia and South Africa are both Commonwealth countries. Do you think South Africa decision may be persuasive as far as Malaysia is concerned, Maidili?
It may be persuasive, but it still comes down to when they do decide to expand the definition of who an author can be, or if an AI can be considered an entity of its own. So until that happens, yes, Commonwealth countries' decisions can be taken into account, but it's not binding.
Okay, so let's say I file a patent and I name a machine as an inventor, okay? And I come to you and say, Ms. Maidili, I have this invention. I'm not the inventor. My AI is the inventor. Would you tell me go ahead and file, or would you tell me don't file because your patent will be rejected? Without looking at the novelty and all those things. Suren and rest of you can also chip in here. So this is not a very legal question. It's purely a logic answer.
I would ask them to name the human as the applicant.
Sorry, say that again, sorry.
I mean, instead, I would ask the person to name the inventor to be named as the person human.
Okay, but that's not for me. It's unethical because I didn't invent the invention. I invented the AI, like labels, for example, and my AI created the so-called invention that I intend to file. I can be named as the applicant. I have no problem, but I don't want to be named as the inventor because I didn't do any work whatsoever with the invention. Nothing to do with it.
AI is like an extension of the inventor. Actually,
Sorry, Maidili, I couldn't hear you. Can you repeat that?
sorry. I would take the AI as an extension of the inventor of the AI. So it's not that the AI created the invention, but it was just a means or method by which the invention is created.
Okay, so would you recommend me to file the patent application and you say that I have a case, or you will tell me don't waste your money?
I would say still file because the invention does need protection, but I would not say that the process would be smooth. I would advise that you are most likely to face obstacles because this is still a very new situation in the IP industry.
Do you think this question is open to everyone? Do you all think that MIPO may reject my application without looking at the substance because I named an AI as the inventor?
It might be the case when they're doing formality check.
Yeah. Okay. So in Malaysia, remember, when you talk about Commonwealth or UK, while the decision is persuasive, it is a non-binding. Okay. The courts will look at the decision of South Africa and the UK and Europe and all that. So if you look at South Africa versus UK, by the way, UK also rejected the patent, patent. So if we have a decision from the UK and that actually conflicting with the South African decision, Malaysian courts, Malaysian Patent Office will normally rely on the UK. It probably be more persuasive. Okay, but let's say in the event that the UK says okay, the patent can be granted, but the rest of the Commonwealth countries say no. Okay, the UK will still have quite a bit of influence because our laws are very much UK based. Okay, so if it's UK, I will say yes. Our courts and the patent officers will be looking at the decision and try to bind ourselves to those of the UK decision. But otherwise, they will look at it and they will not carry a weightage unless UK say the same thing. Right? So in this particular case, I will probably tell my client, if I were you, I will tell the client, don't waste your money. unless you want to file a patent for the AI itself. For example, how you created the AI, how the AI works, but not what is the output of the AI. Okay. Suren mentioned that why don't I name myself as the inventor? That's a question that actually the court actually asked Dr. Taylor, and Dr. Taylor said the same thing like what I said. That's unethical. I did not invent the thing. Okay, it was Debus. I invented Debus. Period. Debus invented the bottle. So how can I claim myself to be the inventor? Right? Okay. So just to share with you, the answer is probably no in ratio 2. Okay, let's go back. Okay, so after this, we'll be discussing about various types of other IP rights very quickly. So the next thing that probably you guys, those who even have not done any IP work, they will be familiar with trademarks because we buy things, we sell things. Every product, every service will have its own brand. Okay, so trademark is actually being created to protect the brand in order for people to not misrepresent themselves that both of us are related when we are not. For example, let's take Norlela as an example. Can one Norlela register a trademark called Norlela or Lela? Is it possible to register a name as a trademark? And Suren said can. Okay. Others? Can. Can one Norlela register a trademark called Norlela and say that I want to register a trademark that covers all goods and services? Therefore, I can block others, everyone else from calling anything that they do with the name Norlela or Lela. Why not? If I register imported by charter, I mean, Norlela wants to cover every item in the world, both goods and services, right? Yeah, she's Suren said she must use show that she's using. Fair enough, but that's for another day. Yeah, because to register the trademark, I don't have to show use. But if somebody were to challenge my mark, probably yes, then I have to defend myself, right? So assuming Norlela as a mark is not a problematic mark, there is no similar, no identical, by right, Norlela can be registered. But can she register a standard form? No. Okay, it has to be stylized. So in the form of signs, for example, right? So you cannot register NORLELA. So it's supposed to be a special form here. So technically, a name can be registered. Okay, technically you can register all goods and services, but as Suren correctly said, you need to show you use if someone were to challenge your mark. That is the reason why not many people register trademark for all goods and services, because you don't sell everything. Okay, there will be certain things that you do, most of the things that you don't do. So you have to limit yourself to the goods and services that you are selling or offering. That means third parties can use Norlela for goods and services that Norlela did not register. Remember, the law says anything that is not claimed is disclaimed. Okay, this is a statement in the court that if you don't register, you don't claim, too bad, that's your problem. You cannot come back and say, sorry, I overlooked that. Okay, so it's very important for you to make sure that when you register a trademark, you claim as many goods and as many services as possible. Okay. Now, there are many types of trademarks. There is something called word mark, there's something called device mark, composite, color, scan mark, 3D mark, sound mark, etc., etc. Okay, I will show you some examples on these types of trademark. Also, people always confuse the symbol R and TM. Remember, R stands for registered. You only use the symbol R if your mark is registered in that particular country. Let's say your trademark is registered in Malaysia and you are selling in Singapore where your trademark is not registered. Okay, definitely is an offense in Singapore because you are using something to misrepresent yourself that your mark is registered and it's not. Okay. TM, a lot of people think that TM can only be used if once you file a trademark application. That is wrong. TM can be used even if you don't use the mark. Sorry, even if you did not file the trademark application, as long as you are using the mark. Okay. TM. So even if your mark is registered, TM is perfectly fine to be used. That is the reason why in some goods and services, people don't put R because in some countries the trademark is maybe not registered. Okay. Now the question that I need to ask you is that in Malaysia, do you need to mark the trademark? Meaning, is trademark marking an important element for you to claim infringement or to protect your trademark? Can I sell my product without the R symbol when the trademark is registered, or without a TM symbol, even if my trademark is pending for approval or being used or whatever? Okay. Can I see some answers in the chat? Do you know what is trademark marking, right? The R symbol and the TM symbol. Can you sell your product without the R symbol or the TM symbol? Okay. What is the implication? Is then why people put the TM and the R? Public confidence. Good point. Others? Why would you need the TM and the R? It's part of marketing, correct? I agree. Is there any legal requirement for you to mark your trademark as TM and R? What happens in Malaysia? Your trademark is registered. Sorry, yeah. Your trademark is registered, but you don't put the R symbol. Will that affect your trademark ownership or your scope? It is not mandatory, but misrepresentation is wrong. I agree. Misrepresentation in this case is that you claim R when your trademark is not registered, or you are hijacking third-party mark, and then you put the TM. Okay. Student said it will not affect the scope. Can a third party challenge my trademark and say that your mark is not valid because you did not put the R, and therefore I did not know your mark was registered? No. Okay. Remember, in Malaysia, ignorance is not a defense here. Okay, that's what the law says. Okay. Just because I don't put the R, just because I don't tell you my trademark is registered, does not mean that you are free of infringement. But in the US, okay, ignorance can be, to a certain extent, can be a defense to reduce the amount of damages that you can claim. Okay. Hence the reason why patent marking, trademark marking is very prominent in the US, and because US being the superpower, most countries start following the same process. So by right, the TM and the R symbol is not required. Even if your patent, even in the case of patent, you don't have to mark your invention to be patented. Okay, but like Leila said, it can be part of the marketing too. It can also be part of the the valuation of the company. So people knowing that you have an IP, so when people want to acquire your company, then the valuation can be increased because of that. Right? So it's not compulsory, but definitely something that people are using more often than not. Okay. Okay. Let's look at some of these examples. Okay. You will see Edifon on the bottom left center. All right. This is what we call as a composite mark, whereby you have a logo, the dot and the signature line is actually makes that invention as a composite mark here. Now, Edifon is a word, but it's a stylized word, okay, special font. But if you see Louis Vuitton on the top right hand side, it's a standard font, nothing fancy about the font, black in color, okay, no other color. Black is also color here, by the way. Black and white is also color. Okay, it's in black. If you compare Edifon and Louis Vuitton, which one has the widest protection? The answer is Louis Vuitton because they claim standard font, they claim black and white. In other words, Louis Vuitton will cover all variation of the font because they change standard. If you change standard, you are covering all fonts. If you file your trademark in black and white, that means you cover all colors. If you take, for example, the likes of Philips here, Philips was filed in blue. Technically, people can use Philips in other colors. Of course, Philips can be a bit tricky because of a well-known mark, so there's always a risk of passing off, which is a different issue. But I hope you understand that the way you file a trademark application will reflect your scope, especially if you're a small company. Of course, if you look at the Apple symbol, Apple on the bottom left, that's a very famous brand. Okay, you don't need to put a word Apple in order for people to know that the company, Apple company. All right. So if you are very famous, you go with the only logo. If your mark is unique, you don't have any conflicting or similar marks in the market, you go with black and white standard font. If there are similar marks, or if you have your mark may not be approved smoothly, then you go with a composite mark. So that will give you, while it will give you a narrower protection, it is still a protection nevertheless. Okay, but scan mark, sound mark, color mark, these are newer mark that was introduced in Malaysia back in 2019. Okay, so technically, if you look at purple and you say a chocolate product, you may want to relate to Cadbury. If you hear a particular sound of a motorbike that is very unique, that you probably will associate that to, say, Harley Davidson, for example. So anything that actually represents the company can be a trademark. So it's not the usual logo brand. Yeah, the so-called non-conventional mark is also a trademark. Okay, some statistics similar to patents. This one also we got from MIPO. I got from 2019 to 2023. The number is subject to the accuracy of MIPO database. You will see that unlike patent, trademark, the percentage is almost the same. Say for 2023, almost 22,000, and foreigners fall about 26,000, so almost 50%. Okay, even the trademark registration also quite significant number, because theoretically trademarks are much easier to be registered compared to patent, because the registrability threshold, the requirements are not as difficult as patent. Now, look at this space. In 2023, we received about 35,000 trademark applications. But if you remember the statistics for patents, we received about 8,000 patent applications. Do these numbers give you any idea, anything to explain the condition of the country? You have 8,000 patents, 45,000 trademarks. What does it mean? That means that particular country is actually a trading nation. Any country that has lesser number of patents compared to trademarks is a trading nation. We buy and sell. Countries like Japan, you will be surprised to know that they actually have more patents than trademarks, because for them, what sells is the technology. They don't care about trademarks. I mean, I don't mean they don't care at all. They still do, but if you ask them to give priority, they will give priority to patents. So we have a country like Malaysia where you have more trademarks. We have countries like Japan where you have more patents. What do you think about China? Is China a trading nation or is an R&D nation? Either one. You're not wrong, Chok, because they have quite a very big number of patents, no doubt about it. They are the highest in the world, okay, in terms of patents and trademarks. So they are both, but if you ask me, China is still a trading nation because they still have more trademarks compared to patents. Countries like Japan and US, they have more patents compared to trademarks, okay? So that is actually a very good indication where you stand. So by that, if a country wants to become a developed state, you need to have more patents. That is not true all the time here. It depends on the country, but that you get the gist of it. Yeah? Okay. Okay. So people will ask, are brands and trademarks are the same? The answer is no. Brand is something that describes the goods or services. Trademarks are something that don't describe the goods and services. For example, we were discussing about Norlela as a trademark, right? If I say Norlela, and you never met Norlela before, you don't know who that person is, you don't know what products and services that person offers, okay, sells and offers, okay, would you automatically consider Norlela as an IP practitioner? The answer is probably no, because non-legal does not mean IP or IP practitioner. Okay, so that means non-legal is a word is actually a very good trademark, but unfortunately it's a very bad brand because the same reason you don't know what non-legal is. But if I say, for example, coffee house on the left hand side here, the spectrum, rightly or wrongly you assume it's actually a coffee. Like a premises that sell coffee. Okay, so it becomes a good brand because I don't have to educate my customers, but it's a bad brand because there'll be millions of coffee houses in the world. How can you say that you are the only coffee house in the world? Therefore, you say every coffee house, every businesses that carry the word coffee house will be into your trademark. Okay, remember, brand and trademarks, they always conflict. They always opposite of each other. A good trademark is a bad brand. A good brand is a bad trademark. So keep that in mind. Always advise your client what they want to achieve. Whether they want to get a good trademark or whether they want to achieve or get a good brand. That will actually change the way you answer or advise your client on how to move forward with the trademark. Okay. Now, we talk about passing off just now. Okay. So I just shared with you a few cases maybe involving trademark passing off. Now, when you talk about trademark infringement, if you register ABC and somebody uses ABC doing the same services or selling the same goods, okay, then it becomes a direct trademark infringement. But more often than not, people don't copy directly. They will try to modify, try to confuse the consumers into believing that both of us are related and we are not. So this is where the concept of passing off comes into the play, into the equation. In other words, the law in Commonwealth countries and some other countries as well, they provide provision for you to sue someone for infringement, even if trademark infringement, even if the trademark is not identical. In Malaysia, there was a case started in year 2000, McDonald's versus McCurry. So as you can imagine, McDonald's sued McCurry for passing off because the trademark, they thought or they assumed that because of the word MC, the letter MC in front of the word curry, consumers will believe that McDonald's and McCurry are related when they are not. Okay, so the matter went to the first round was in the High Court. McDonald's got an injunction, and then in year 2008, the matter was went to Court of Appeal. Gopal Srilam, the late Gopal Srilam was the judge for the appeal back then. He said that in order to see whether there's a confusion in the market or not, a simple view of how the words or the names appear is insufficient. We need to look into more than that because the consumers are educated consumers; they are not idiots. Okay, so just because MC appear on both McDonald's and McCurry does not mean that the consumers will be confused. So for the very first time in Malaysian history, trademark passing off history, the court defined how consumers can be confused. What will make consumers to be confused? In the case of McCurry, the court said that they were not using uniform, unlike McDonald's. They were selling banana leaf food, unlike McDonald's. They are standalone South Indian restaurant, unlike McDonald's, which is a franchise business. they don't have a proper restaurant setup, unlike McDonald's. So the court dissected the case very thoroughly, and eventually the court said there was no passing off. Consumers will not be confused. The matter went to court, federal court, and the federal court rejected the relief to appeal. So the decision of the Court of Appeal in the Mercari case stands until today, that any when it comes to passing off, you cannot simply look at on a very superficial level like what the High Court did. It has to be much more complex than that, because the court said consumers are not idiot. Okay, so now that actually brings us to the cases in other countries. For example, the first one on the top and right hand side is like China. This is a UK case. In this case, the court, the UK court said there was an infringement, there was a passing off because the word walk away. So walk away represents takeaway concept, which is also similar to McDonald's. So in this case, McChina case, McDonald's, McChina was held to be passing off McDonald's. But in Indonesia, there's a thing called iPhone and Dr. iPhone. Those who are using iPhone will know that there's such a thing as Dr. iPhone. You, if your phone is broken, your iPhone is broken, you bring back to the customer service of Apple. Okay, so the court said that again. Court said for an educated consumer like iPhone users, they will not be confused to think that Dr. iPhone is related to iPhone when they are not. Okay, even though everything is the same, yeah, you can see how passing off, that shows passing off can be very tricky, very difficult to win. Okay, therefore we need to try to work on trademark strategy to make sure that the trademark is supposed to cover maximum scope, provide maximum scope for the client's benefit. Okay, let's move on. Copyright. This is also very common among researchers, among students, among professionals, whereby anything that you get from the internet, we assume it's free. That is not the case. Okay. Now let's look at photos that I'm using in this particular slide. Okay, I took the Mickey Mouse photo from the internet. I took the photo of the books, the musical notes there. Can those copyright owners sue me for infringement? The answer is yes, possible. Can I avoid infringement? Probably I can. I can probably say this is a fair use, where I'm not making any money. It's purely for education purposes. Okay. Copyright protects work. In other words, if your work has been copied from someone else, then you don't enjoy copyright. Okay. But if that work is actually created by you, you get the copyright automatically, and the work can include written articles, drawings, sketches, source codes, music, lyrics, and written or prepared by machine such as computer. Okay. Now, let's say, Chok, I want to ask you on this question. Okay. If let's say you use my slide, okay, obviously my slides are in Malay and English. You take the same slide and you translate into Chinese. Okay, would you can I sue you for infringement? Remember, my slide has not even one Chinese character. Your slide, everything in Chinese, not even one English or Malay words. Otherwise, it's word for word copy. Same question. If it's showing on my screen, translate that into Tamil or any other languages. Okay. Remember, my slides are in Malay and English. Can I sue you? Just yes or no answer, please. Right? Suren said no. Job said no. Miley said no. How about Malina and Leila? They said no. Malina? No. Okay. The answer is I can sue because you copied my content. Okay? Because what matters is the content. You just translate word for word from Malay to English, Malay and English to Chinese. to Tamil or whatever. But can you claim copyright for the translated version? Yes, it's a different language. You see, language is just a medium, Leila. Okay, if I tell you, Leila, can you go from KL Central to UAE Bangsa? Okay, I tell you in English, I tell you in Malay, I tell you in Tamil, I tell you in Chinese. I'm telling you to do the same thing. So language is just a medium. Okay, so language will not help you with the infringement. Okay, so question now is, I can still sue Choke. Choke can still be sued for using in Chinese. There's Maithili or Surin, if they translate into Tamil, I can still sue them because they are using my content. Question I'd like to ask you is that, can Choke, who translate into Chinese, claim copyright ownership on the Chinese version? Surin Maithili to claim copyright ownership on the Tamil version, for example.
Because for translating to a different language, it can't necessarily translate verbatim word to word.
No, in my case, it's verbatim. So that means word for word. So for all intents and purposes, both steps are the same. I mean, this for discussion purposes, right?
Okay, that's when I guess but if it's not verbatim, then would I be considered its own?
Sorry, Maji, I cannot hear you. Can you repeat that?
If it's verbatim, word for word, just translation, then maybe not. But if there is some liberty in rephrasing and there are words that just cannot be translated, then that would make it a new work. It's copyrightable.
I have to disagree with you. Okay, I can still sue. Let's say just like I'm the copyright owner, right? I can still sue you, Surin, Choke, for using the same content in different languages. Okay, because you use my content. But all of you can claim copyright ownership of the translated version because translation is also an original work. Because you're putting in your creativity, your work into the thing. So remember, owning copyright does not mean that you are free of infringement. Okay, I can own copyright, I can own patent, I can own trademark, but I can still be sued for infringement. Okay, so having something and getting sued are two different things here. So to answer your question, yes, it's possible to get sued for using the content, but it's also possible to get the IP protection, copyright protection for the translation work. Translation is actually a copyrightable work, right? Even though your copy word for word, yeah, right? So in other words, let's say Choke translated everything from English to Chinese, right? Who is the owner of Choke's work? Is it Choke alone or is it Choke and me? Remember, Choke translated from English to Chinese. I'm the copyright owner of the English version. Choke translated everything into Chinese, and he wants to file a copyright application. He comes to all of you and seek your advice. He admits that he copied from Rama. Would you tell him to register the copyright application under Choke alone, or would you tell him to register under Choke and Rama? Supposed to be both, because the content is still mine. The medium is yours, Choke. So the answer is both here, right? So this one can be a bit tricky, so you need to be careful with these kind of answers. Of course, nobody will come and admit to you that I copied. That's a different issue altogether. But if there are someone who genuinely comes to tell you that I copied from someone, then this will be the situation that you have to be very, very careful. Let's move on. Okay, so these are the things that you probably can register: SOP, policies, proposal. Anything that you create can be protected. It doesn't need to be printed copy here. It can be also soft copy. Okay. Now look at the photo on the right hand side. The walls here. You can see the walls here, right? Do you know this is a legit infrastructure in the world? I'm not kidding you. This is actually a proper legit wall. Can you guess which company owns this work? Look at the photo very carefully. The clue is there. Did you notice? You want to see again, or you got the answer already? Please type. Okay, I'll share again. Right hand side, yeah. Which company owns the vote? Yeah, the answer is Coca-Cola. Okay. How you see that is because every time I switch, it closes the switch. Why I say it's Coca-Cola is because you can see the doorknob. You can see the Coca-Cola brand here. See, even without the word Coca-Cola, by just looking at the shape of the bottle, you know it's Coca-Cola. And this is actually one of the 3D marks that we talk about. Okay. So apparently this is where Coca-Cola formulation is protected. The formula is protected. So they only can be accessed. The formulation can only be accessed, known to a few people in the world. Okay. So if you have a very strong mechanism to protect your copyright, sorry, your confidential information, trade secret is the best IP to have, because as long as you keep your mouth shut, don't tell anyone, you don't have to publish, you don't have to spend money registering, yours forever, okay? And it goes from one generation to another, so it becomes a good IP. But it's very difficult nowadays to keep things confidential. So unless you have a proper mechanism like the Coca-Cola of this world, then maybe filing a patent or trademark or copyright will be more beneficial. Okay. So when it comes to business, all businesses rely on multiple IP. You cannot have a single IP to be successful. Okay. Like let's take the example of Viagra tablet here. You can see that the word Viagra is there. It's a trademark. The word Pfizer is there. It's a trademark. Did you know that the color blue is a trademark for Viagra? Okay. So apparently Viagra is the very first tablet that comes with the color. So that's why sometimes they call it blue pill. And then the shape of the tablet is also registered. It was registered as a design. Now it's a trademark, converted to a trademark. Okay. Of course, when it comes to the patent, the use of the drug for treating ED is a registered. It's also been patented. Okay. So that is one example. Of course, you talk about iPhone. You talk about the software, which is the copyright. You talk about the patent, which is a technical mechanism. You talk about the logo being the trademark. You talk about the color, the shape. Sorry, not the color, the shape, which is the industrial design. Okay. Of course, when you talk about Aston Martin, the same thing like what I mentioned just now, right? So in order to have a very successful product, your invention must be protected by multiple IP rights. Do not rely on a single IP, because you need to create multiple barriers for third party to avoid third party to from approaching your. Okay. Not all IP rights require registration. For example, patent, trademark, and design need to be registered. However, copyright, you don't have to register. Trademark, trade secret, you don't need to register. But in countries like Malaysia, India, US, Indonesia, copyright can be registered. More and more countries are now providing options of registering copyright, because without registration, nobody knows who owns what. Okay? So there's a so-called voluntary notification of copyright in Malaysia, whereby you can submit your materials with the so-called copyright office, in order for them to give you a certificate to confirm that you have submitted document to the copyright owner, and prima facie you are the copyright owner of that particular material. Okay, now time is 4:06 now, so we have another 30 minutes plus. I'm going to discuss issues that came up recently that will be relevant from the IP perspective as we discussed, from the trademark perspective, from the patent perspective, copyright perspective, trade secret perspective, so on and so forth. Now, let's look at the first one. This is quite straightforward. Myanmar, for the longest time, they did not have IP rights. And every time people ask when they're going to introduce IP, the answer was soon. Okay. When I first started in the year 2000, a lot of people, when we asked our agents in Myanmar, when you're going to introduce your trademark laws and your patent laws, the answer was soon. Even until now, the answer was soon. Okay. However, in the last couple of years, things changed quite dramatically in Myanmar. First, they introduced a mechanism to register trademarks. Okay, and that has been quite stable now. So recently, they introduced a system to register patent in Myanmar. Previously, how they register patent, it's not like register. In a way, it's more like a recorder of rights with the registry of records in Myanmar. What people used to do back then, before the current system, is that let's say the patent has been granted in Malaysia, they take the patent document, they submit to the registry of records, deeds, they call it, registry of deeds in Myanmar, like a bank, to deposit your material to say that you have registered the patent elsewhere. At the same time, they'll also publish a warning notice in the newspaper, like a cautionary notice, I should say, whereby they notify the public that the patent has been registered under their name. If you ask me, does that have any legal effect? The answer is no. But it's just to put to the public knowledge that the company, the owner has acquired a patent in other countries, but no legal rights. But now, Myanmar has introduced a system to register patent, and interestingly, the system is not very different from the rest of the world. Okay, the novelty requirement, the inventive requirement, industry applicability requirement are the same as the rest of the world. You will have the process of filing also the same, more or less the same. The only thing that you need to be a bit careful is that in Myanmar, you need to file the patent either in Burmese, which is their official language, or English. Okay, if you file in English, you don't need to translate into Burmese. Okay, so that will help a lot of foreign clients to file patent application in Myanmar now, because you don't need to translate into Burmese or any other languages here. So if your clients do have business interest in Myanmar, or they are planning to start business in Myanmar, it's about time to register their trademark and patent in Myanmar. At this point of time, they don't have any protection for other areas of IP like industrial design or other such as copyright, so on and so forth. Yeah. So patents and trademarks are now open for companies, applicants to protect in Myanmar. So it will be a very important aspect for Myanmar IP perspective. Any question there before I move on to the second topic? Okay. Now, let's look at the second point. This is actually a very, very recent. This happened last Friday, right? Okay. Last Friday being the 22nd of November 2024. Okay. Most of you, I'm sure, heard the term Parmesan. How many of you have not heard the word Parmesan? Parmesan? Yes or no? You know what is Parmesan? What kind of goods items is that? Cheese. Okay. So it's a cheese product. Parmesan, apparently, when you look at the translation into Italian language, right? Parmesan apparently means the name of a location in Italy, the region where Parmesan cheese was created. Okay, so those who are familiar with GI is in a way similar to trademark. It's just that in trademark you cannot register a trademark with the name of the country or name of a location, city, so on and so forth, because that is prohibited under the trademark law. But under the GI, under the geographical indication law, you can register a GI with the name of a country or region or city or locality, provided that you have a unique quality associated with that product. So all this while, Parmesan has been recognized to be something that originated from that particular region in Italy. Okay, let me share screen again, right? So if you read the news that came out last Friday, in fact, I've shared with you also. In Italian language, Parmigiano Reggiano means the region. The Reggiano means region. Parmigiano is where Parmesan is created. So if you look at it, Parmigiano Reggiano means a place where Parmesan cheese is created or comes from. Okay. So in this case, Court of Appeal in Singapore actually heard the case and decided last Friday, whereby the court said that Singaporeans do not associate Parmesan with the region in Italy, because there are so many Parmesan versions in Italy, and bulk of them do not originate from Italy. Forget about the region, not even Italy. So the court declared that Parmesan cannot be a GI. Okay. So what happened in this particular case is that now a third party, this company called Frontera, is not able to sell Parmesan cheese without infringing the GI of Parmigiano Reggiano. Okay, so this will create, it gives us a different perspective now. All this while in Malaysia, at least, the fact that the population in the country do not associate a particular name to a particular locality does not mean that the GI is invalid. Okay, but Singapore has made a decision, Court of Appeal in Singapore has made a decision that the knowledge of the locals is important element in order to give GI protection or otherwise. So this is actually a very surprising result, especially that comes from Singapore, okay, because they are very business friendly. They didn't want to create an issue, but the decision is out. Now, the question that I'd like to ask Suren and Maithili, being from legal background, can the Court of Appeal decision be appealed in Singapore? Suren, Maithili?
Can,
Mr. Does Singapore have federal court or Supreme Court? Why the Singapore Court of Appeal decision has been published? What we call extensively. If there's another court that can overturn the decision. What is the highest court in Singapore? Highest court in land in Singapore?
Supreme Court. They have a Supreme Court.
They have a Supreme Court, but I can tell you in Singapore, very, very rarely Supreme Court hear cases. Okay, in Malaysia, federal court, of course, federal court, you need to have a leave to appeal. Okay, and they only hear constitutional issues or legal issues involving the interpretation of the laws and so on. But the threshold in Singapore is much higher, that they don't, literally, you cannot get leave to appeal in the Supreme Court. Very rarely you get that leave. Okay, so the decision of the Court of Appeal in this particular case will most likely, like I would say 99.9%, be final. Okay, therefore, as far as Singapore is concerned, the decision that you need to have a local knowledge will play an important role from now onwards. Question that I'd like to ask you is that, do you think Malaysia will follow that decision? Again, Singapore being our neighbor as well as a fellow Commonwealth country. No. Okay, I will agree with Suren, because as far as the UK is concerned, and GI is a very European thing, right, as you can imagine. So I don't think UK will make such a decision, dramatic decision anytime soon. So I would imagine, unless UK makes a similar decision that you need to have a local knowledge before a GI can be protected, Malaysia will stay status quo. Okay. Local knowledge may or may not be important as of now. Okay, but definitely the Singapore court decision will be looked at by the Malaysian court whenever GI is considered. Okay. Now, do you know the famous GI case in Malaysia? What do you mean? You probably heard the case of which one is that? The rice case, Pony. Do you remember the case of Pony? No? Might be a meter, yeah? You heard or you never heard? Okay. Pony is the very first case in Malaysia involving GI and very first case in that where GI and trademark intertwined because you see, Syarikat Faizal filed a trademark application called Pony Faizal Pony Rice. Okay, for those from India, those have some link to India, they will know Pony is actually a delta in India. Okay, and the rice that comes from the delta has been given a GI protection. So when the Syarikat Faizal registered a trademark called Faizal Pony Rice, MIPO trademark office accepted the application and the trademark was accepted, registered eventually. So the Indian government sued Syarikat Faizal in court to declare the trademark to be invalid because it misrepresented Syarikat Faizal's rice to be something that originated from Delta, only Delta, when it's not. Okay, so that's a very famous case where Malaysia, the very first GI case and very famous GI case involving trademark and GI. Right? Okay, let's move on. Malaya International School. Now, I mentioned just now, name of a country, name of a city, name of a location cannot be registered as a trademark in Malaysia. And in fact, that is true in other countries. What happens if the trademark is an old name of a particular country or city or locality? Can a trademark be registered, be approved by the trademark office if the name is no longer in use? So this case involving our own firm, we filed a trademark application for a trademark called Malaya International School. As the name suggests, it's actually for education sector, it's a school, and they use the term Malaya. So the trademark office rejected, the examiner rejected the application because they say that Malaya refers to a locality, a location, a jurisdiction, and therefore it should not be approved. So we attended a hearing with a hearing officer recently, about 2-3 weeks ago. And the point that we brought to the examiner's attention, the hearing officer's attention, I should say, is that the trademark examiner overlooked one important element when it comes to saying a trademark cannot be approved if it refers to a particular place, right? If you look at the act, the law says, the section says, it cannot represent a name of a country, city, or region that is registered or being used, okay, and is part of an international convention. So when you look at any international conventions where Malaysia is a party to, or even if it's not a party to, Malaya name, the name of Malaya does not exist anymore. So our argument to the hearing officer was that Malaya being an old name that was used by the British to refer to the so-called Federation of Malay State during the before the independence, should not limit our clients from getting the trademark registered, because that name does not appear officially in any government what do you call that government documents, instruments, international or local. So based on our argument, the hearing officer accepted our point, and only Friday night, we received the approval from the trademark office saying that the trademark has been accepted. So, bottom line is, if the name of the country, locality, or region is being used and is being recognized in the legal instrument locally or internationally, then your trademark cannot be approved. If it's an old name which is not officially being used, even though certain portion of the population or history historians are still referring to that particular name, the old name, that should not prohibit from the trademark from being registered. In fact, we supported our application because certain names like Harimau Malaya was registered as a trademark. There's a restaurant that actually registered a trademark called something Malaya. I can't recall the name now, unfortunately, sorry guys, but the name Malaya, okay? And therefore, and the trademark office actually approved those applications. So it's only fair for our clients' application to be approved. Now, let's move on to the very interesting case that is happening in the world of Indian movies, Indian cinema. How many of you know Nayantara? How many of you know that Dhanush? So, do you know both of these things? Maithili said no. No, Maithili said yes, sorry. Sorry? Yes. Leila, Amalina, Chok? Chok said no. Amalina and Leila? Both names here. Amalina? No. Okay. Now, they are very famous. Both of them are very famous actors from southern part of India. They are not like a throughout India famous kind of a thing. But they are quite famous, very successful actors by their own right. Quite senior. They are probably in the industry for almost 20 odd years now. Okay. Question that I would like to ask you is that if I take a photo of a person standing before the Twin Tower, who owns the copyright to the photo? Is it Petronas being the owner of the Twin Towers, or the photographer, or the subject of the photo? Imagine you're standing in front of the KLCC here. Photographer, okay, photographer, Maithili and Chuk. All of them. Chuk. Photographer. Okay. By default, it's a photographer. Okay. That is the how paparazzi can make money. Okay. You know, paparazzis, they go around chasing all the celebrities, take photos, standing on the tree, hiding behind the bush and all that. They take photo and all that. Okay. So if the copyright owns of the photos is owned by the subject of the photo, then paparazzi job is definitely redundant. Okay. So in this particular case, Nayantara Dhanush case, what happened was Dhanush his company produced a movie some time back where Nayantara was a leading actor, the heroine in the movie, and she fell in love with the director of the movie during that shoot. Okay, so recently, I think about a week.
Ms. Rama, you're muted.
Can you hear me now? Okay. So like recently, about a week or 2 weeks back, there was a documentary in Netflix about Nayantara, how she became a very famous actor from nobody into and then up to the time where she met the husband, the director of the movie, and the wedding, which was like a very celebrated, where all the top VIPs of the country attended the wedding and all that. Okay, so it was for Netflix, by the way. So Nayantara, because remember I told you Nayantara and her husband met at the shooting spot during the movie, and they actually had some footage of a video and photos that they took using their own mobile phone. Okay, so Netflix, because Netflix being Netflix, they need to be a bit dramatic, otherwise nobody wants to watch their program, right? Documentary, right? So what they did was they actually asked Nayantara to get no objection certificate from Dhanush company, saying in order for them to use the footage from the shooting spot. Okay. Apparently, whether this is true or not, obviously we don't know. This has been going on for the last 2 years, and apparently Dhanush company did not respond to the request for the footage. Okay, so the Netflix trailer came out a month ago, and in the trailer there were 3-second footage. Okay, about the director, the future husband, and Nayantara talking by the beach during the shoot of the movie. He sent a warning notice, a legal notice to Nayantara and Netflix, seeking how do I say this? 10 crores. I don't know how 10 crores. I don't know. Is it 100 million? Because in India they use crores, so I don't know what is in Indian. So okay, for argument's sake, it's 100 million Indian rupees as a compensation for them to use the footage in the trailer. Okay, so that lady, I'm sure she had a very good PR team. She kept quiet, and then the day Netflix was supposed to air the documentary, she posted on Instagram, Instagram, a 3-page long document about her response to Dhanush, saying that this guy is being ridiculous, asking for 100 million rupees for 3-second footage, and that he's being very it's not right, it's wrong, blah blah blah. It's a 3-page long, so she used that as a way of promoting her documentary, no doubt about that. Okay, but this issue became big because of that. And in order to overcome that issue, because he didn't get the he didn't give the no objection certificate, they actually used the footage from their mobile phone, remember, and the documentary came out. In the documentary, apparently there were about more than 2-3 second footage of from the shooting spot, probably up to a minute, and he filed a suit against Nayantara now and Netflix India. So the question I would like to ask you is, the footage was taken from a mobile phone that belongs to someone else, not Nayantara, so not Dhanush company. Are they free to use the footage? Remember I said the copyright belongs to the owner of the device. Like in the case of photo, then the photographer. If it's a videographer, then the person used the mobile phone to take the video. So can Dhanush succeed in court? What do you think? If so, what is his claim? Remember, the device is not his. Okay, someone took the video, so he cannot claim copyright to the footage, can he? The answer is no, he cannot. But he still sued. He is still asking for 100 million. He said, you took the footage during in my shooting spot, in my set, which I paid for. Therefore, the footage, the copyright to the footage is mine. Forget about the beach and all that. There's nothing to do with the beach. Yeah, beach is a public property, but the set is his money. So therefore, he should get the compensation. So this will be a very interesting case. How do you determine copyright ownership on something like in a structure that is being paid for by a third party? For me, my personal view is that he doesn't own the copyright, because if that happens, then nobody can take a photo in front of the KLCC. Petronas will come after them. Okay, you cannot take a photo in front of a third party, like a building, a landmark, or whatever that is built by others. Okay, unless they waive that rights. So for me, Dhanush will have a big problem, but to my knowledge, this will be the first test case for us to know what will be the outcome. If the Indian court decides that Dhanush should be compensated, then any future cases in Malaysia will have a big implication, right? Something for you to look out for. That's the reason why I shared that case. So will be good to know, and then will be interesting update in our legal jurisprudence on how copyright can be claimed. Is it only the footage, or is it where the footage is taken? How is it taken? What actually enabled the footage to be taken? So all these issues will be a very crucial element for us to look into. Right? All right. So any question there before I move on to the last slide? Yes, ma'am.
Because she's making a commercial profit out of it. If it was something that was just shared, like not in a money making scheme, then I don't think that, I mean, that's what he wrote in his response to me.
Fair enough. Fair enough. Obviously, he's making money, no doubt about that. But let me put it this way: if you shoot a movie in front of the Twin Towers, okay, can Petronas come after you? That is the thing that I know it's not a direct comparison, because Petronas is not a structure that was built purely for that movie perspective. I know that, but that's why I say we don't have a reference case to make a comment. But the point here is it was a structure built for the purpose of a movie, and therefore anything happens inside will be the IP of the producer. For me, it's a bit stretched, far-fetched, because you are trying to claim anything happens there. If somebody does a Instagram reel shoot and all that, who owns it? No, it's a bit far-fetched for me, but it'll be interesting to watch out what will be the outcome of this case. Okay, so I will keep you posted on the development of this case. And you guys also you should follow this case very regularly, so that you know what is happening there, right? Let's move on to the last part of the presentation. All right. So that generally a very short introduction of how what are the IP rights that are relevant to the businesses. By no means these are the complete details of all the IP rights that you need for business. Yeah, there'll be hundreds of them. Okay, because this is just an introduction. We look at the topics that we will be looking at. All right. In the next part, for the next 2 hours, we will be discussing about how certain cases involving IP being decided in Malaysia and the rest of the world. That is actually after like 15 minutes break, we will be continuing the discussion, right? And do you have any question before we end the first part of our session today? I welcome your questions live or in the chat. Any questions, any comments? Anything you agree or you don't agree? Okay. If no questions, thank you very much for joining us today, and for allowing me to share some details about IP to my knowledge. Yeah. All right. So keep reading, keep yourself informed of the development happening around the world, because IP is not a Malaysia thing. It has any changes in the international international will have impact on Malaysia to a certain extent. Yeah. So always keep yourself informed so that you can advise your clients the latest update on the legal practices around the world. Right. With that, I will end my session today. The session is being recorded, as you know. Thank you very much for joining, and see you soon in 15 minutes time for the second part of the presentation. All right. Thank you, everyone. Thank you.
Thank you.
Thank you.